Let's just dive right into this, guys. Welcome to The Explainer. Today we're unpacking an absolutely incredible underdog story that comes straight out of the 2005 Constitutional Court of South Africa. It's the case of Johann de Kock versus, well, a whole host of powerful respondents, including the state and a massive industrial giant. It's a truly fascinating look at environmental law, everyday citizen rights, and the frankly towering hurdles of the legal system. It asks a pretty huge question. What actually happens when the mechanisms built to protect us are just way too complex to navigate? Seriously, think about it. What happens when one single citizen, completely without a lawyer, tries to take a giant steel corporation straight to the highest court in the land? We're talking the ultimate David versus Goliath narrative here. You've got one totally unrepresented guy on one side, and on the other, massive government ministries, including the president of the republic, no less, and a tremendously powerful corporation. The whole setup seems almost impossible from the very start.
So, let's kick things off with Part 1, One Man's Pollution Fight. To really grasp the sheer magnitude of this case, we have to look at the massive stakes involved for Mr. de Kock. He walked into court completely without legal representation to take on iScore, which you might know today as Metal Steel South Africa. Now, this isn't some mom-and-pop shop. We're talking about a massive integrated minerals and metals company manufacturing steel products out of sprawling steelworks in places like Vanderbijlpark. De Kock actually cited the state, specifically the Ministers of Water Affairs, Forestry, and Environmental Affairs, for totally failing to prosecute iScore for the severe pollution caused by all this factory activity.
And his argument? It was rooted in something fundamental. Section 24 of the Constitution clearly states that everyone has the right to an environment that is not harmful to their health or well-being. De Kock argued that his environmental rights and his property rights, given the health dangers caused by this pollution, were being directly violated. So the absolutely crucial takeaway here is that this wasn't just some dry, technical legal dispute. This was a man literally fighting for his health and well-being.
Which brings us to Part 2, skipping the legal line. Now, typically, a case like this takes a slow, honestly agonizing route. You start in the lower courts, slog through the appeals process, and maybe, just maybe, you eventually reach the Constitutional Court. But because de Kock didn't have a lawyer to guide him, he went for a total legal Hail Mary. He applied for something called direct access under Rule 18 in Section 167(6)(a). His goal? To bypass the lower courts entirely and knock directly on the front door of the Constitutional Court. He basically wanted to skip the line completely.
But unfortunately for him, this is where he hit the brick wall of legal precedent. In a previous ruling known as the Mkhwanto judgment, the court firmly established that just saving time and money doesn't justify jumping straight to the highest court in the land. And this perfectly illustrates a key tenet of how high courts actually work. Supreme and constitutional courts rely incredibly heavily on the groundwork laid by lower courts. The fact-finding, the initial views. The more complex the issue, the more the highest court really needs that lower court to do the heavy lifting first.
Moving on to Part 3, the direct access rule. You see, direct access makes the Constitutional Court the very first and the very last stop. That is exactly why the rules governing it are so notoriously strict. To even be considered under Rule 18(2), you have to prove it's in the interest of justice, pinpoint the exact nature of the relief you're asking for, and lay out how to handle oral evidence and any conflicts of fact. De Kock, flying entirely solo and without any formal legal training, well, he simply couldn't untangle these massive procedural knots in his application.
So, because of all that, the Constitutional Court had to deliver the bad news. The strict requirements just weren't met, and direct access was officially refused. Case closed, right? Well, not quite. This absolutely does not mean the matter ended there. In fact, this is where our explainer takes a truly unexpected, fascinating turn.
Let's look at Part 4, a desperate cry for help.
Even though the court had to refuse direct access on technical, procedural grounds, they couldn't just ignore his stark, isolating reality. Before he ever set foot in the Constitutional Court, de Kock had pleaded for help from virtually everyone: the Department of Labor, the Mfuleni Local Council, the Public Protector, the Human Rights Commission, even the President. He was even turned down for legal aid. It's just this incredibly overwhelming accumulation of closed doors and nonstop rejections.
But looking at this history, the Constitutional Court recognized something really profound. They openly acknowledged that, quote, without legal assistance, this applicant will struggle to bring properly a case. They saw a guy trying to raise an issue of genuine critical public interest, asking tough questions about environmental rights, who was just entirely trapped in the sheer complexity of the system.
Which leads us nicely into Part 5, an unexpected legal lifeline.
Instead of just stamping denied and synonym pack-in, the court did something completely unprecedented. They issued this incredible final directive. Recognizing de Kock's relentless efforts, the obvious public interest at play, and the civic responsibility of the legal profession, the court ordered its registrar to take this very judgment straight to the Law Society of the Northern Provinces. They formally asked the Law Society to see if one of its members could offer Mr. de Kock pro bono assistance. The court even threw out the idea of collaborating with environmental academics or specialized NGOs. Talk about a real game changer. It was a literal lifeline thrown from the highest court in the land, all to make sure one lone citizen could finally get a fair hearing.
And that, my friends, leaves us with a final, vital question to think about. When complex environmental issues pop up, issues that deeply affect our health, our well-being, and our constitutional rights, how on earth do we make sure everyday citizens get the legal support they actually need to be heard? De Kock's story absolutely proves that having a right on paper just isn't enough. You need the tools and you need the guides to navigate the system and protect that right. I really hope this explainer sheds some light on the incredibly intricate balance between strict legal procedures and the fundamental pursuit of justice. Thanks so much for joining me on this deep dive.